Hi, y'all, and welcome to tonight's live stream. Lori Vallow Daybell is headed into a buzzsaw right now, headed for an absolutely epic disaster of a trial because she is not at all ready to go to trial. Jury selection starts in a week and a half, but Lori Vallow Daybell is just not prepared. She is already in jail for life, convicted in Idaho of murdering her daughter, Tylee, her son, JJ, and the wife of her lover, now husband, Chad Daybell. Now she's on trial in Arizona, charged with conspiring to murder her own husband, Charles Vallow, so that she could marry Chad Daybell. Now, she has been warned repeatedly against representing herself, but she insisted. She's been offered an extension of trial to give her more time to prepare repeatedly, but she has absolutely refused that also. It's a disaster in the making, and we are about to get a front row televised seat for it. Now, right now, when Lori Vallow should be finishing up the last touches on her defense, she is, and I'll give you three things that happened at yesterday's hearing, just to give you an example. She is focused on getting a video that apparently does not even exist and isn't important even if it does exist. Secondly, she is naming new witnesses for the first time, a week and a half before trial is, before jury selection, which is the week before trial begins. Many of those witnesses probably are going to be declared irrelevant by the court, and others will probably be blocked out, will not be allowed to be brought to trial because she has named them too late. And then the third thing is she's trying now at this late stage of the game to name an expert witness. It's way past the normal time to be naming experts, but even more than that, he hasn't even begun to work yet. He hasn't even begun the preparation for his testimony. He hasn't even gotten the phone from which he would be supposed to download data. So you can kind of only feel for her advisory council, who must be just frantic having to sit there and stand by and just watch all of this happen. The question is, will Lori Vallow Daybell be able to pull it all together? Because it does not look possible at this stage. The only thing that could really save this for Lori Vallow Daybell is a continuance to put off the trial. It's very easy to get that. The judge has offered it over and over, but she has absolutely adamantly refused. She is fighting against it, and frankly, it's not at all clear why. So special shout out to the first five in the chat tonight: Carol Sue Scott, Michael Lalonde, Oklahoma Gigi, Bonbon RPH, and Angel LaFawn. Also, special note, Friday night, 7 p.m. Eastern, we are having an once in a lifetime special show. We are having, my dad is turning 90 years old. He's a longtime listener, lives with me, and he is going to be on our show answering your questions. You talked him into coming. I couldn't do it, but when y'all all responded to the post that I put out saying you wanted him to come and asking questions, he's now going to come. He is going to be answering questions that only a 90-year-old can answer. Like, after 90 years, what are the biggest changes you've seen in technology? What do you think? And y'all have given me a whole list of questions like, what are the things you need to know when you're looking for love? How do you have a good relationship with your adult children? Things like that. So I can't wait. That's going to be Friday at 7 p.m. Eastern. So definitely put that on your calendar, and we will look forward to that. So he will actually be turning 90 that day. So getting into the Lori Vallow Daybell pretrial hearing that happened yesterday, the pretrial conference, she is absolutely obsessed with finding another angle of a videotape from the Gilbert police. What happened was that her friend Melanie Gibb, you will remember her if you followed along for the Idaho trials, and her daughter, Tylee, Lori's daughter, Tylee, went to the police to report that Charles Vallow, this is Lori's husband, the one she's on trial for conspiracy to murder, that Charles Vallow had supposedly taken Lori's purse. And she has the video. She has the video where they went to the police to report that this had happened. clearly, and we're going to go through that another night, maybe even tomorrow, but we're going to go over it really soon. It's an entire videotape, and it says so much about what is going to happen in this case. So we will definitely get to that, but I'm going to give you a little snippet of it tonight just so you can understand the flavor for what it is that she wants to put in evidence. The thing about it is she's not on trial. He's not on trial for taking her purse. That's not really relevant. Clearly, taking a purse doesn't equate to needing to be murdered, and it isn't even violence. It isn't even as if it showed he's just a kind of guy who gets really upset, angry, and then turns violent. He just took her purse. It isn't anything more specific than that. But she already has the body cam for this. It's not super relevant in the first place, but she has the body cam. What she is so focused on getting and spending a lot of her energy toward is a view of this exact same interview taken from a camera within the interview room. So there would be a body cam that the police take of it, but there would be a camera up in the ceiling looking down. We did see views like that later on, for example, when she was interrogated after Charles Vallow was murdered. I'm guessing they maybe don't bother to turn on that camera when the issue is someone took someone's purse, a husband took a wife's purse and locked the door, as opposed to murder has just taken place, or at least a death and someone's been shot. So that's my guess as to why there's not one. But she believes that her attorneys or someone working on her team showed her, in fact, a video where there was that perspective. I'm guessing she's gotten it mixed up with the other interviews. But in any event, all it is a different view of the exact same thing she already has. Let's take a look at this little snippet so you can get an idea of what it is.
Tell us what happened.
So yesterday, I got in an argument with my husband on the phone, and he was in Texas working, and I found some stuff that he'd been doing, so he was really defensive. And so I took the kids. We spent the night in a hotel because I knew he was coming home. And so this morning when I took my son to school, which he goes, I went into the school to take him into school. He was waiting somewhere and like stole my purse out of the car, my whole purse. So my phone, my wallet, my money, my everything was in there. So I had the door locked, but the sunroof was open because we have a service dog and he was in the car, and I didn't want to, my son was kind of throwing a fit. I didn't want to get them both out of the car because it was a mess this morning. And we didn't have any of our stuff because we spent the night in the hotel and he was out of his element. So I didn't lock the door for the first time ever, and he whatever, either got it out, I don't remember if the door was locked, he got it out, or he reached through the sunroof and just got it. Okay. But then he started texting all my family and all my friends and impersonating me, and got my friend lured over to the house to meet him, where he had kicked in the door to get into the house and stuff. So
You did that this morning?
last night,
Okay.
which I'm glad we weren't there. So.
Right.
The defense had.
So it's not that Lori doesn't have a point. Obviously, if Charles took her purse, if Charles kicked in the door, if Charles impersonated her to get Melanie Gibbs to come over, all of those things are really inappropriate. The police took action. They called Charles Vallow and said, what are you doing? And turn over the purse. They did the things that you would normally expect them to do. The question is this hugely, massively important in the case against Lori for conspiracy to murder her husband? And it's not. It's obviously of completely different character and nature than the question of whether or not someone took a purse. Those are two really different things. But at this point, she is pushing this really hard, really wanting this video. She filed a motion asking for it, insisting that there's more and that she's seen it and it's out on the internet. So the prosecution says, well, we looked and we don't have anything more than what we just showed you.
They motioned for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that
This is the prosecutor, by the way.
relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already
I'll tell
disclosed.
you,
Like, so she clearly is not letting this go. She clearly believes that it still exists. She is not buying what the state said. She believes it still exists. I personally looked for it on YouTube. I couldn't find it either. I couldn't find the overhead view. All I found was the body cam view that I showed you. And I agree that it's very blurry, and maybe that's what bothers her, and she wants it to be clearer. And there are reasons why she would want that in evidence. It's not that it's crazy to want that in evidence. It's just that she's got what she needs in terms of what comes into evidence. She doesn't really need anything more than that. And the prosecution may oppose it in any event. But one of the facts that clearly emerges right here is that Lori has a lot of hostility for the lawyers she kicked off this case when she took over. She dives into them. She's very angry, and the judge backs her up on
I
something.
will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn down any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know.
I left this in because I was really fascinated by this. I'm going to give you my speculation in just a minute. This is Lori's lawyer who just walked away. I don't know. I might have something to say. I'm not sure. She's going to come back in just a second. She's obviously checking with somebody on something. I thought she was upset. I thought she had stormed off. And I thought, wow, maybe she disagrees with something Lori was saying, but I don't think that was it based on what she says when she comes back.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. Let me ask you.
So I don't know why the lawyer got up. At first I thought, okay, she's upset. She's upset about what Lori just said, but she seemed so calm when she came back. So maybe she was checking to see if there was maybe a letter in the file that said, this is all we have, or something like that. If the attorneys didn't turn over the whole file, that really would be kind of surprising. It would be very, very inappropriate. Lori Vallow Daybell would definitely have a very valid complaint that the entire file should have been turned over, because that is the rule, that you turn over the entire file. If you stop representing a client, then you turn over your file to the next attorney representing them. So I don't know exactly what the deal is, and I'm assuming the lawyer may have thought maybe there's a letter in the file that will just clear this up and explain that they sent everything over. But whatever it was, they just rocked along. The judge did side with Lori and said, I'm going to put out an order, and I'm going to say, if you have anything, you have to turn it over. So even if there is a conflict and you shouldn't be talking, you have to turn over your file. That's still necessary. But Lori is just obsessed with finding this very low value, almost certainly non-existent evidence. And there are more problems with her being ready too. This is not the only one. For example, she is also naming brand new witnesses not named before. And it's well past time. This is coming in at the last minute. The judge hadn't even seen it. And it creates a huge burden on the prosecution. The prosecutor wants to interview the witnesses before trial. Has that right? It would be very critically important to do that. You're warned never to ask a question as a lawyer unless you know the answer to it. And in this particular case, they're not going to know the answer to that because they won't have talked to the witness. So she's saying, I want to go talk to the witnesses, but she only has a week. She's in the middle of trial prep and has a week till she's supposed to go into jury selection. So it is really, really too late for that. And as I said, creates a huge burden for the prosecutor to try to deal with. The defense has not provided them with contact information or set up interviews, although apparently the investigator working with Lori is trying really hard to do that. The prosecutor and judge are asking now in the course of the hearing, are you going to be providing that sort of information?
Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one.
Which is who?
Which is Nate Eaton.
Okay, we have to stop there because Nate Eaton, what? All right. First of all, I'm a huge fangirl of Nate Eaton from East Idaho News. Just love his show, love what he does great work. He runs East Idaho News. I think he must own it or at least runs it. So he has followed this case from the very beginning. If any of you saw the sort of iconic moment when Lori and Chad were in Hawaii and there's a reporter following them, Lori, where are the children? Where are the children? And she gets off the airplane. She's brought back to Idaho and she gets off the plane and Nate Eaton is standing there. Where are the children? Where are the children, Lori? And it's just iconic moments where he was trying to get the story. What does he have to do with this case of Charles Vallow? When Charles Vallow was killed, he had never even heard of Lori Vallow Daybell. He had no connection to the case. He didn't know about it until the children were discovered to be missing, and that's months after Charles Vallow was killed. So it's really confusing as to why she would want Nate Eaton. I'm so curious about it. Poor guy, I know he doesn't want to be on. I kind of just want him to be on there just to figure out what would she ask him, because I really am at a loss. I don't know what her plan would be for what she would ask Nate Eaton, but he clearly should not be on her witness list for any good reason that I can think of. And I think I'm pretty creative. So let me say some shout outs to KCAM4, who has been a member for 7 months. That is awesome. I'm so glad. And Kathy Smith has been a member for 3 months. Thank you. I really appreciate that from both of you. And Bama Queen has been a member for 13 months. We must have hit 13 months tonight because this is brand new. Bama Queen, you were on the forefront of our membership. So thank you very much. I appreciate all three of you. All right, so we are now going to move into some sort of whining from Lori Vallow Daybell, and she's both right and wrong when she says it. She talks about how difficult it is to run a case from inside prison, and she's right. It would be extremely difficult, but she's also wrong in this sense. That's why you are given an attorney, is to let them smooth out those things, to know the system and to know how things work. The only reason this is a problem is because she is representing herself.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
And I don't doubt for a minute that it's extremely difficult. But the fact that they have to find these people is only part of the problem, because probably for a lot of these people, they don't even have current information. So the prosecutor has to find these people herself, it sounds like, if she wants to, and interview them. So once she figures out what these people are going to say, the prosecutor then has to prepare and file a motion in limine to keep their testimony out if it's not appropriate, and has to do all of that right now this week in the middle of their trial preparation.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
They'd be called, I'll have to deal with that as it comes up.
Well-
But if they're unable to be located or interviewed, obviously they won't be called at trial. All right.
So see what's happening. These are witnesses that Lori Vallow Daybell says she needs for trial who have relevant information, but there's a good chance that they will not be available for trial. They will not be allowed to testify, or they won't be able to be found to testify at trial. So that's a huge problem. It means she hasn't given enough runway to go out and find the witnesses, even from her point of view. Because if she can't find the witnesses and she can't serve them and she can't get them at the trial, they're not going to be of any help to her at all. And I thought I would pop up real quickly Rule 405 that she's talking about. Oh, I have to remove this first. Okay. Now add that. Okay. So Rule 405 is methods of proving character. So if you want to put in evidence of someone's character for truthfulness or just whatever for character, first of all, when evidence of a person's character or character trait is admissible, it has to be admissible. We'll talk about that in a minute. It may be proved by testimony about the person's reputation or by testimony in the form of an opinion. Notice that on cross-examination, they can look into relevant specific instances. And under that, by specific instances of conduct, when a person's character or character trait is an essential element of a charge, claim, or defense. And it has to be, again, relevant. So the important point about that is you don't just get to come in and say, Lori Vallow Daybell is a great person, or Charles Vallow was a terrible person. That's not relevant. You aren't allowed to do that. It has to be an essential element of what's being proven. And Lori Vallow's character isn't an essential element of whether she conspired to murder him. So the prosecutor is going to argue that none of that comes in. For example, she had on the list her mother, her father, two of her brothers, and her nephew, and and a sister. Maybe it was only one brother and a sister. But in any event, all of those are going to be relatives, and the speculation is maybe all they knew about was either her character or maybe Charles's character. And the prosecutor is giving the court a heads up. I'm going to argue, court, that this isn't an essential element. This is not that important. It isn't one of the things we have to prove in order to make this claim or this case. And it's not relevant for that reason. So that's what she's talking about there. Let me
It's
add.
premature to address these today. the state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
So super smart move by the court, because what the court is doing is saying, you know, a lot of these may not really be a problem for me because she may not have current information and may never find them. So I'm not going to make rulings on this now. I'm going to wait and see whether this actually becomes a problem. And if it does become a problem, then we'll worry about it. But you can hear the prosecutor talking. This, I think, in this particular case, the state is very likely to make a Herculean effort because of the media coverage, because Lori is representing herself, because they do not want this case reversed on appeal. They will do everything they can to make sure Lori Vallow Daybell gets a fair trial. I think they will go out and look for these witnesses, try to find them if they can. Normally, you can certainly see their incentive would be, why would they bother to go look for the witness if the defense can't find them? But I think that they'll, at least if they're given this, are going to try to reach everybody on the list. I think they'll make an effort for that. But then they are going to either, for many of them, they'll probably argue that they don't even come in. Now, there's yet another problem with Lori Vallow Daybell and her preparation for trial, and that's that she wants to add a brand new, at this stage of the game, expert witness named Dworkin. Now, normally, kind of the way it works is one side will name an expert witness. This is who I plan to have as my expert witness. Sometimes the person does a report and details what they're going to find. Sometimes, depending on the state and so forth, there might be a deposition where the prosecution, in this case, would get to ask the person questions or would be allowed to interview them to learn what it is that their opinions are. And then maybe the state would need a counter expert. Maybe this is something new and they need somebody to counter and go against whatever it is that they say. But how can the state even conceivably do that with this particular witness who's just now being named? They don't need, it's going to take, he hasn't even looked at the material yet. So he doesn't have opinions yet, much less will the state have time to respond to that with a brand new expert. And at this point, he hasn't done any of the work at all. He is going to download data from cell phones, and they asked for multiple cell phones. Lori Vallow Daybell asked for multiple cell phones. But in this particular case, you're going to see that Lori very wisely lowers that to just one. But he hasn't even gotten the cell phone yet, much less has he downloaded the data, much less has he analyzed it and drawn any conclusions.
For the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own Cellbrite or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
So the court throughout this hearing and throughout the lead up to this hearing and throughout the case has really bent over backwards to help Lori Vallow Daybell and to give her every opportunity. If she were represented by counsel, this would be going very differently. They would be telling the lawyer, absolutely not. You cannot name an expert witness now. You can't name your witnesses now. None of this is okay. And that's what they'd be saying. But she's getting extra breaks because she's representing herself. And you can see the court giving her special chances. Oops. Let me add that back.
Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
The report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the, let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
And this is where she makes a very smart call, which is she limits her request to make it more likely that the court will give her what she wants. So she does do that.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
When you just compare the level of preparation at this stage in the game with, say, where the Karen Reed team is, the difference is just extraordinary. This person hasn't even looked at the data. There isn't some theory such as this was fabricated or things were left out or there were deletions or anything like that. They haven't even looked. There's no plan here. There could be something there or there could be absolutely nothing there. And there's a very easy solution here. The solution is they could delay trial. The judge is offering it over, you're going to have to make a choice. We could delay the trial, but she doesn't want that. And I have to say, I don't understand why not. I don't get it.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dworkin says, that
Well,
would
it
put
could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that months, if not over a year.
more than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January, and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay.
So you see there how the judge is repeatedly giving her special chances and opportunities. An attorney would not be allowed to try to let this person have their 10 hours. I can understand Lori Vallow Daybell probably had no idea that she should be applying for this person and for funding for this. And so she didn't know that. She just took over the case where she was going to represent herself. I don't remember the exact time, but she's now learning that, and she figures out, oh, wait, I need to apply for this. It takes a couple months to get approval. But normally that's something that has to happen maybe a year before trial, substantially months and months. But she is insisting on her right to a speedy trial. And so she's pushing this. She's pushing it, even though it's clearly going to cause disadvantages. The judge, once again, very wisely not ruling on this because he may have nothing to deal with. It could be that she just can't get the expert is on vacation this week. The expert can't do it. And so there may be nothing for him to rule on or to worry about. It may never get brought up. And if it is brought up, as he said, it might get precluded. There may be some reason why it doesn't come in at all. So, but the judge gives her more and more warnings.
All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me. And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery.
So they come up then with a plan to figure out, okay, how is it going to be picked up, just practically speaking. And she comes back around at the end of the hearing. She comes back around to that video of the overhead camera view of the exact same interview that there's already body cam for. But she's back to it, even though it's already been decided she didn't understand exactly what the court was
Anything else
ruling.
from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or
Who do you want me to, I was going to say give it to your advisory council. Do you want a more narrowed?
The judge offers, he again trying to help her. How about if I do a little narrower order for you so that all what they have to focus on is the one thing that you're saying that you really want, because what you might get is boxes and boxes of things that you don't have time to go through. So he offers to narrow it down. He's trying to help.
Order maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
So at this point, you can see where the judge is making such an effort to help Lori Vallow Daybell and to give her every opportunity. And it is a very dangerous point in the case for the judge and for the prosecutor. And the reason is because it's becoming more and more apparent that Lori Vallow Daybell really isn't prepared to take this forward, that she isn't doing the things that even she thinks she needed to do, because she's just not sure how and where and when, and she's not getting it all done in time. And so she's not going to have all the evidence that she would want. And they don't want anything to jeopardize what they believe will be a positive verdict for the prosecution. They believe she'll be found to be guilty, and they don't want to jeopardize that on appeal by having a lot of flaws in what's happened and in her inability to present the evidence. So you can really see where the judge is trying to help out. He's trying to bend over backwards to help her. Let me say thank you to a few people, and then I want to go into a few more details we learned about what's coming in the trial for Lori Vallow Daybell. So first of all, Coco, thank you for the super sticker. Much appreciated. And Lorelei Annie is saying hearts and love to Kay and Larry Woodstock. And they are the grandparents of JJ, one of the two children of Lori Vallow Daybell, who was found buried in Chad Daybell's backyard. And they certainly do deserve justice. That's certainly true. And we will hope that justice always prevails. That is obviously the goal of the justice system entirely. Nana of 7, how much other people's money can she spend? Husbands, kids as taxpayers, Tammy's life insurance, taxpayers, and is concerned about that. And there is definitely a cost for the taxpayers in this, because taxpayers, not me particularly, because this is in Arizona, but people from Arizona will be paying for, they would have been paying for her lawyers, but she doesn't have any. So I guess she's saving some money there. Maybe she should get extra credit. But the expert witness will cost all of the costs for the investigator. She has a paralegal assigned to her. She does have advisory counsel, and they would have to be paid as well. So all of those costs are coming from taxpayers. And you're absolutely correct about that. Nana of 7, you're right. So the judge explained how it will work if she testifies. She has to write the questions out in advance and give them to her advisory counsel, who will read them out to her. It'll be really awkward because, there are just things that a witness says that you want to follow up on, but there won't be any follow-up. So if she heads off on a tangent, then it will just be a different question entirely coming next. There won't really be any follow-up, but that's how it'll work. She's not allowed to do a narrative. We've seen that in a few other cases, but she's not allowed to just talk about what happened. She has to answer specific questions. So at trial, her investigator is going to be allowed to sit with her, and the investigator can, I guess, help her during the trial if she needs any assistance. The trial is being moved to another larger courtroom. Now, that was something the prosecutor had asked about and had wanted. The judge at the last hearing had said, no, that's not happening. But apparently something occurred. He's changed his mind. So now it's going to be in a larger courtroom, which is a great relief for people who will actually be present in person. It would have been really difficult from what I understand. So as far as picking a jury, there is a questionnaire going out to potential jurors. The judge sort of wrote one up. Everybody's going to approve it. And then both sides will follow up with questions when the jurors show up in person. The prosecutor wanted to ask the jurors about whether or not they had heard of Tylee or JJ, because was concerned that maybe they wouldn't respond to Daybell or Vallow, but maybe Tylee and JJ would be familiar to them. And they wanted to make sure that they're getting a full sense of people who know about the case and therefore conceivably could be biased about the case. So Lori Vallow Daybell agreed to that. So their names are going to be put on a special section of the questionnaire called, something like names you might hear at trial. The trial is, according to the prosecutor, she wants jurors screened for not just jury selection, which is already set for a week. And she said maybe it could be longer than that, but that there would be 20 days of trial. So that would be 4 full weeks, and then 2 half days. So about 4.5 weeks. The goal is to finish this case, and then on May 30th, begin the case for the shooting of Brandon Boudreaux. She's also charged in that case, but it's being tried separately. And that case, the goal is to get it finished before July 4th. So there is lots to come in this case. There's going to be so much more on the way. At this point, If you have some questions, if you would go ahead and put them in the chat with question marks at the beginning, that'll help me spot them. While I'm waiting for questions to come in, I want to remind you all, Friday night at 7 p.m., our show is going to be, I'm going to be asking my dad your questions. He is turning 90. So we're going to ask him questions only a 90-year-old can answer. And what he's seen, what are the changes he's seen, what's his best advice? Y'all had some great questions. If you have questions, we're going to put out another post to tell everybody this is coming up. If you've already put your questions under the first post I did, you don't have to do it again. I've got those, but I'm going to put in another post. And if you haven't had a chance to put in your question yet, go ahead and put that in. We're going to be live, and he has never done anything on social media ever of any type. So this should be very, very interesting. So, okay, let's see what some of the questions are in here. Diane Van asked me, I think she thinks they have to dismiss the case if they cannot oblige her speedy trial right. Although she's been warned, can these issues cause a problem on appeal? Well, they're moving forward. They're giving her the speedy trial within the parameters that they had. For example, they had to do an evaluation to determine whether she was competent to stand trial. So that took a little time. But they're actually accomplishing getting it done within the time frame so she can get the speedy trial. So I don't think they're going to dismiss the case because of the speedy trial. I mean, I don't think that there's going to be any appeal ground on that. I think they moved forward on that. Maybe there would be some appeal ground in that they charged her years ago and then finally brought it. But as far as what's happening now within the contents of this court, I don't see that being a problem. I think that she is incorrect about the amount of time that's been spent once she was brought down there and so forth. I think they've been pretty careful. Michelle wants to know, will the jury know of her prior convictions? Great question. We'll deal with that more in another video. But in general, if she testifies, the judge warned her, your convictions are going to come in. So the answer is not unless she testifies. But the judge is at least probably not. The way it will come in is if she gets up there, the prosecution will be allowed to impeach her and talk about her credibility based on her prior convictions. So that's something that the judge warned her about at this hearing and said, remember, if you get on the stand, this is what's going to happen. They're going to hear about your convictions. I think she's getting on the stand. Put your vote in below. I'm very curious. What do you think? As far as, do you believe that she will testify or do you think she won't testify? Very curious what y'all think. So stick a 1 for you think she will testify and a 2 for you think she won't testify. And we'll talk about that. All right. Susie 0505 says, why Nate Eaton? Indeed. Why poor Nate Eaton? I don't know. I assume she thinks something about him. I don't know. It really seems irrelevant because maybe there was something related to when they were looking for the children, but he really came onto the stage long after Charles Vallow was shot. I don't really see how it connects to that. Maybe that she thinks he has information, say from an interview that he did, that might shed some light on it. So I don't know. I'm very curious. Poor Nate. I don't know. I don't really know what the idea is. Okay. Oh, thank you, Mickey. Mickey has been a member for 13 months too. That's forever in Lawyer Lee channel terms. So, and wants to remind everybody to hit the like button. Thank you, Mickey, because of course I never remember that. So please hit the like button. Also subscribe. We would love to have you join us. We go live Monday, Wednesday, and Friday, 7 p.m. Eastern, and would love to have you with us. Thank you, Mickey. And Bethany gifted 10 Lawyer Lee memberships. Awesome. We are in the midst of writing our very own true crime novel. So it's going to be a blast. We've already done our first little bit. We're continuing to do that more. So definitely join. It's a lot of fun and we have had a good time. So thank you, Bethany, for gifting that. And in the chat are mods who are fantastic. Marlon, mamapinks, denisepelton will put in how it is that you are able to turn on gifting so you could receive a gift if YouTube chooses you. They do that randomly. We don't have any control over that. Megan Tomlinson, so glad your dad will be joining. Me too. Me too. I think it's going to be really interesting to hear. I'm curious too. What will he say? 90 years old. What is his advice for us? What are his thoughts and what has changed? I'm curious too. So I'm looking forward to it. I think I'll learn a lot too. All right, so let me head back over and answer a few more questions. Does the advisory council look annoyed to you? Her body language is very revealing. What do you think? Peggy, I can't really tell. I mean, we kind of got the side view in the back. I at first thought she was storming off in that one section. I clearly not, because she came back and said, I'm good, Judge, nothing to say. So obviously that was incorrect. She was simply getting something done. It would be an unbelievably difficult position to be in, to be advisory council right there. It'd be so hard because your client is doing things you don't want them to do, and you can't do anything to stop it. You can only help when requested to, but you aren't allowed to just say, no, stop. And you can't do the things you want to do. It'd be very hard. Mace also wondering about Nate Eaton. Poor Nate. I don't have any answer to that. I don't know what could possibly be the reason Nate Eaton is picked out. Why not all the other people who have covered it? Why Nate? I don't know. It seems so unfair. Claudia, will Lori interview for the jury, or will the other members of her team? She will. She will be doing the actual questions. She's representing herself, so she will be allowed to do voir dire just as an attorney would, and she'll be asking direct questions of the potential jurors. It's going to be a very, very strange trial. It is going to be wild. Betsy Sue just called me. Betsy says they only have court 4 days a week there, so 5+ weeks of trial. Thank you, Betsy Sue. That would extend it out, because it was 20 days of trial plus 2 half days. So that's going to stretch it out, maybe even more than 5 weeks. Very long trial then. Amanda Simpson, if she steps out of line with the witness, what type of sanction could the judge give her? Great question, Amanda. And I think the judge is going to be very, very careful about sanctioning her. And that's because he'll be very afraid to prejudice the jury in any way. If it were a lawyer, he knows that the jury can separate the lawyer from the client to some degree. So he's going to, he might say, you can't do that. Might yell at the lawyer and not be as concerned about it. But he's going to be concerned about doing that with Lori Vallow Daybell, because she is the person they are deciding guilt and innocence for. It totally different environment, totally different question for him when he does that. So I would think almost all sanctions would be private. And I guess she'll go up and talk to the judge at sidebar, I guess that's how it'll be done. But I would think that is how they'll do it, separately, and he'll try to keep it as quiet as possible. As far as exactly what he could do, I think it's the same range he could do with an attorney, except obviously he can't report her to the bar because she's not a member. All right, Lee T, can you explain what a mitigator is in this context? Lee T, I looked it up, like, what is a mitigator? And I think it's a mitigation specialist, someone who is determining what factors might go in mitigation. In other words, childhood or things that might make the jury, it usually would apply more in sentencing, but what are the things that might apply in mitigation? In this case, maybe it includes reasons that she would have been afraid of Charles when he came with that bat. Maybe that would be included too, but I don't know. I will look at that too. I'm not totally sure. I didn't find a clear answer on the internet. Nano7 wants to know, does it make any sense that Lori wants a speedy trial yet experts? Why not a continuance? Indeed, Nano7, the very question the judge, the prosecutor, everyone in the courtroom is asking. Why? You have the chance for a continuance. And, when you think about it, what is the big deal about having this speedy trial? What does she care? I mean, she's in prison for life. This is the only vacation she will ever get for the entire rest of her life, is going to a different prison in Arizona. That's it. This is the biggest thing that will ever happen to her for the entire rest of her life. This is the biggest moment in time. So why is she in this huge hurry to finish it up, get it done, and then to go back to Idaho to serve out the rest of her life in prison sentence? I don't understand why she's so bent on it being a speedy trial, even at the cost and expense of the evidence that she thinks is important enough to be pushing for, important enough to apply for an expert, but then she well may not get it. She may be thinking, yeah, and I can see where she's thinking 10 hours. I mean, there are many more than 10 work hours in a week. I've only got 10 hours approved. We'll just hand this to him and he'll spend his 10 hours and then he'll come and testify. Why is everyone so bent out of shape about this? Why is everybody worried about it? And maybe it'll be that easy, but that isn't normally the way it works. It's normally a month's long process, just like the judge had recommended or the judge had mentioned. Okay, I think I've got a couple people back over here. Kelly D joined the first day I offered memberships. That is awesome. I am very happy you belong here too, Kelly D. So glad to have you along. And you know, Chickenhead, PK, Dorkface, Neely. Well, that's a long name. Why Nate Eaton so confused, right? I think we all are. I am really confused too. I mean, I don't know. Maybe he wouldn't interview her. And so this is the closest chance she had. I just don't know. I do not know what she's thinking, why it's so important to have that. Kathy wants to know, since she is serving life in prison, what difference is this case going to make for Lori Vallow Daybell? In practical terms, probably nothing at all, because life is life and she's got more than one. So there's just nothing, there's no possibility that she's ever getting out. This is it. The reason she might want to pursue this, there are a couple of reasons, that more than one, probably more than two. But if for any reason the case in Idaho were to be reversed, I can't imagine what it would be that would cause it not to ever be tried again or be thrown out. But if that were to happen and it were to be reversed, well, she's always got another conviction in Arizona. That's the thinking of the prosecution. But another issue is just the fairness of it, the justice of it, because if you kill more than one person, it's not really justice that the family never gets to come, they never get the testimony, they never get the evidence, they never get the conviction. That's part of what the way our justice system works, is we let people get that sense of justice as meted out through the justice system. So if she kills multiple people and only gets tried and sentenced for one, it might be just it might be a savings in terms of how much money it costs, what it costs for the state, but it isn't justice in the purest sense of the word. So I'm guessing that Arizona wanted to do two things: nail down the fact that she has multiple sentences in multiple jurisdictions, so she really, really won't get out, and also to make sure that the people locally and the people involved in Charles Vallow's crime, although there is substantial overlap, of course, right? Since Charles Vallow's sister is also obviously involved in the Idaho case. But I think those are the reasons, the primary reasons. Diminished capacity. If Lori testifies, her prior convictions will come into play. That's correct. And the judge warned her about that. The judge said, if you testify, warning, warning, that your prior conviction may come in at trial, and gave her the site. He said, we're going to have a 609 hearing, which relates to the admissibility of prior convictions. And he said, we'll talk about that. It will be coming. Oh, I'm looking at all the ones. My goodness. Oh, I did see a 2. Okay, all the ones. Okay, well, I'll look back through that later. Thank you for your votes. I appreciate that. Lonnie Dworkin testified in the Jody Arias case and was not believable, says B. Whoop. If it's the same witness, if you've seen that, do you think he'll be credible here? I don't know. I did not see that, so I don't really have an answer for that. Certainly, you would think people would grow and improve their abilities over time. So maybe he's very credible here, or maybe there's a total difference in what he's going to be testifying to here. My understanding is this particular Dworkin is going to be testifying about Celebrite data and extractions from cell phones. I don't know the bent or what their point is, but that's what the subject is going to be. All right. Well, do not forget, Friday night, 7 p.m., what you can learn from a 90-year-old. We will be talking to Dad, long-term supporter of the channel, long-term subscriber of the channel, and I can't wait. I think it's going to be a lot of fun. So 7 p.m. Eastern, and I will see you all then. Oh, what am I doing? I can't leave yet. We have an unbelievably special, very exciting outro prepared by Marlon, our moderator. It's in honor of Dad. So it's only going to be played like 3 times or so, however many times, a few times. We'll play it a few times. It's so cool. You will not believe this. It's really, really cool. It goes through all the inventions. But the best part is the happy birthday rendition at the end. You have to stay for the end. You are going to love the happy birthday rendition. It's like a hillbilly country folk person. You just have to see this. It's awesome. And Marlon, thank you so much for doing this. Dad is going to love it. Here you go.